quite to learn from him, and sharing dice with him has really been like a dream come true. Friends, so with respect to my session today, what I have tried across is try to give you another perspective. So I had the pleasure and the opportunity to be part of giving deposition before the select committee. I had presented my views. In fact, I was invited to Delhi also to summarize views given by all other associations. So very closely I have been a part of this new income tax act that has come through. And I would just like to give you a perspective wherein I just wanted to share these thoughts that whether the efforts that has been put across into this new act, has it been worth it or not? There are many points through which, if you open any press release of government, or if you, it would be wrong to say, but if you see or hear any of the lecturers, everyone would say that one of the core intention is, it would reduce litigation, it would reduce litigation. So few of the aspects with respect to how litigation, whether actually it is being reduced or not, or whether what has been thought through with respect to introduction of this new act, that is being achieved or not, that we'll try to understand across. So friends, I have the fortune of, working into advisory, giving advice, working into litigation. So whenever a case or a brief comes, the approach is to first understand the facts, then try to research across the topic itself. Now that we are in such a situation, or whenever any brief or advisory comes, first the approach would have been try to see taxman, tax sutra, try to read across, Sampath Iyengar or Nani Palkhiwala, the commentary, and to understand what is happening, what not, try to reach out to various, reading journals and journals of BCA, CTC, WIRC, to understand, get few points. So these were regular things that we were doing. Just one fine day when I was having a discussion with one of my friends, and he was trying to understand that, has the approach changed when we try to research or not. So I was just trying to explain, and through this I will just try to explain that how this approach has changed. See, in the press release also, that was earlier released by the government with respect to the new bill, simplification was one of the primary objective and motive. Reduction of litigation was one of the byproduct, or one of the intention through this simplification. That is what it was. But now when we read the basic aspects, so there was this one thing that I was explaining to my friend, that Supreme Court, there's a Supreme Court decision which talks that, decisions should not be lengthy enough. Nowadays you have quite a lot of, Supreme Court decisions which goes into pages and pages, like even in charities of ORDA or, New Noble, you had decisions going into pages and pages, above 100 pages, with index, giving reference to what it is, what not. So there's a Supreme Court decision which actually says that decision should not be very, as in it should not be very long, because it creates difficulty in interpretation. That itself decision is more than 100 pages, which says that decision should not be longer. Same thing has occurred over here. When they talk of simplification, now what exactly is happening over here? See, what was happened, the government decided or realized that, income tax has become complicated with respect to the act. The intention or the approach was, let's simplify it, bang on, which is very much required. But the approach that was adopted, now I'll just try to make you understand what happened. This bill that, or rather the act which has now become, this new act that is developed by department. It is not specifically developed or written as a new act or a new bill is prepared by the legislature. It was taken into consideration by department officers. So you had department commissioners, various commissioners, they worked across on things. And this would be reflected also when we, during this small talk earlier, that why or how this bill or this act has been drafted. So this decision was taken that, we need to simplify. So a select committee was formed, It was a 31-member committee. You had all the MPs. It was headed by Baijan Pandaji. This committee was formed. The committee undertook study tour. It undertook, or rather it held many people. It accepted depositions from various stakeholders, including ICAI. It took stakeholdings. It took inputs from various legal counsels. So if you would see, in fact, the study tour was taken on entire India, pan-India basis. You had likes of Shri Percy Padewala sir giving inputs to the committee as well. Fortunately, I was one of them who had the opportunity to give few inputs. This committee was formed across, they started taking inputs. Later on, they came out with a report. Any guesses how long or how big the report would be? It was 4,500 plus pages report. Now, the concept is you are trying to simplify an act. The act itself is not of 4,500 pages. The report itself was 4,500 pages. This report was given to the government. It was presented before the Lok Sabha. What the government realized, there are more than 500 changes that have been recommended. A monumental task to amend this. What was done, since this amendment, if it would have been incorporated, it would have created quite a lot of confusion. Already a new bill has come. In that bill, you need to incorporate more changes. So that bill was taken back. A new bill was introduced. New income tax bill was introduced with selected amendments. So more than 500 amendments. I and my team at my office had gone and done the statistical research. Not all recommendations of the select committee was accepted. Around 40% of the recommendation itself have been accepted. Others have not been accepted, which is something which I have always, had this complaint, that when a committee has been formed, at least of that committee, you should accept the recommendations. Because one of the points which I will mention also, we had various committees that have been formed. You had a tax simplification committee headed by Justice R.V. Ishwar earlier, way back. In that also, what points were specified into the committee? The first 2 points which had been mentioned in that committee, those were never accepted by the government. The points were specifically to reduce litigation. Unfortunately, that has not been accepted. But yeah, coming back to this, so what had happened, the bill was withdrawn, a new bill was introduced with selective amendments that have been presented by the select committee. That's it. Not all amendments were introduced. After this, you had presidential assent being given to it and a new act has been formed. After this, you have a budget right now, wherein in the budget, in the old act, amendments, retrospective amendments have been presented. Amendments have been presented. In the new act, which is not even introduced, you have 70 plus amendments. Just understand the state of it. Act new बना हुआ है, इंट्रोड्यूस होने वाला है, इंट्रोड्यूस हो चुका है, पास हो चुका है, but you had 70 amendments amending that act which has not even been implemented yet. That is something which I just wanted to make you understand, that in what and how it's happening across, like what the state of new act is. So coming back to the thing wherein I was discussing how research would have been. So today, if a research has to be done, the research would be, I will open the old Income Tax Act, I will open the select committee report. In the select committee report, there are views given by Ministry of Finance also. I will have to check that. I will first now have to wait, and hopefully we should pray that there is no amendment, because every time from the phase of bill to an act, the government makes an amendment. So this time if that happens, so you would have to see the amendment, or rather the income tax bill before passing by the parliament. After that, reading the 4,500 pages report, and then doing the actual research of what you used to do, of reading various commentaries or not. So just trying to give a reference that the work that we used to do earlier, has quite a lot been, amended into it. So, having just given this reference, I just wanted to ask of so many, august audience over here. Anyone remembers what happened to direct tax code, or any thoughts that, direct tax code would be introduced, it would not be introduced? Any thoughts, any show of hands, any scope of possibility that direct tax code would still be introduced once again? Or whether the amendments have already been incorporated into the new act, or it has been incorporated in the old act? Any thoughts? So again, when I had this fortunate opportunity of, being before the committee, I had presented this point, that why exactly do you today require a new act altogether? The answer, of course, given was simplification, which I tried explaining. It is not helping to that extent. And the other answer that was provided across through press release was reduction of litigation, which we'll just understand, which is not the case. I'll just try to give you the framework. From the year 2009, in the year 2009, this concept of, DTC as well as GST, it was incorporated in the parliament. In the budgetary speech, it was mentioned across that, a direct tax code should be introduced. A discussion paper was introduced in this. It was presented for public for comments. So many of seniors would be knowing direct tax code of 2009 was implemented. After that you had 2010, and it just continued. It is only in the year 2015-16 it was said that, there's no merit in going ahead with the direct tax code as it exists today. Reason given was most of the important points that is there in the direct tax code have already been incorporated. Just giving you a reference, same would be the case going forward, as in direct tax code was a very ambitious project that was introduced by the government. But later on what happened, it was similar. In fact, in direct tax code, you had each and every section that was trying to be redrafted, powers were given, this, that. Vis-a-vis, if we do a comparison of what the current Income Tax Act is, it is just mere copy-paste. What has been done is, there's active to passive voice, that is what has been done. See, I'm not here only to criticize, but I'm just trying to make everyone aware of that. Firstly, the only or the major change that you see in the new Income Tax Act is of section, that's it, section numbering. That's the only hurdle. Other than that, any major significant change that ought to have happened or should have been happened is not done, which again I'll take a moment and I'll explain it to you all why I'm saying so. Again, explaining you the preparedness of this new Income Tax Act to be implemented from 1st April 2026, right? So just 4 days ago, on 12th, there was a standing committee. Earlier when I was referring, it's a select committee that was formed. This is standing committee on finance. They gave a representation to Lok Sabha, in which there was a specific paragraph talking across what is the preparedness of Income Tax Act 2025. Everyone or most of you might have seen, there was a newspaper article or headlines that only 54 forms are available and would be available by 31st March. What is the reference of it? So I'll just give you a reference. So out of 170 forms that are to be available, only 53 would be available as on 1st April 2026. The rest of the form are still under draft stage. They are being modified depending on what is required, what is not required into it. Few aspects that I'll just try and make you understand, or I'll just read verbatim what has been specifically given. Rules for the purpose of said act is Income Tax Act 25, are required to be formed as a part of the delegated legislation within a period of 6 months of effectively of the law, that is by 30th September 2026. This is the official response given to Lok Sabha, saying that all the rules need not be necessarily available as on 1st April 2026. They said the rules need to be implemented within 6 months time from the implementation of the new act. So government itself is giving an answer that the rules to support the act can be introduced up till 30th September 26. However, it continues, it says, in this context, it is submitted that the draft rules have been made public on 7th of February 2026 for seeking comments from various stakeholders. Therefore, rules as a part of delegated legislations will be notified within and likely within March itself. However, the actual statutory period that has been given by the committee to the Lok Sabha, which is the decision making authority over here, law passing authority, is 30th September 2026. So even if on 1st April or say 10th March or 10th May or June or somewhere, if all the rules are not notified, we shouldn't be in a state of shock, because the official timeline and the time limit given over here is 6 months from the implementation of the bill. There are one or two aspects with respect to what would happen to circulars, what happens if the rules are introduced later, from which year would it become applicable. Those controversies are there. I'll just try to touch upon it as time permits. Further, few things that we need to understand and what was presented. So for the income tax department to be prepared, whether their systems are updated, whether their systems are not updated with respect to the new act. So there is no specific major modification done by the income tax department, because they say it is not required to be done. What has happened, it is not like in companies when we shift from Tally to SAP or something, when that migration thing happens, that is not happening in the ITD software. What is happening is basically, and it is not that they are running another software, so there are two softwares that are being run parallelly. In the same software itself, certain tweakings and modifications have happened, due to which there is no necessary for running two separate softwares. I'll just read verbatim what has been prepared. With respect to the preparedness of Director of Income Tax System in respect of Income Tax Act 25, it is stated that the implementation entails corresponding development work from IT framework, which does not require major amendments into the income tax software. So just giving a clear reference, what is happening today into the income tax software ITD which the department operates, it will remain one and the same. So whenever there is an official excuse given by income tax department कि system चल नहीं रहा है, new system implement नहीं हो रहा है, there's hardly that we can do into it other than listening. But yeah, the official reason given is there is no delay or lag expected, because there is no transformation happening, there's no further thing being introduced into it. It is just through one click, you click over here 1961, one click you click and you get 2025 perspective data and other things. So this was just something that I just felt it is important to give a reference out to you as in how it would happen. Just a second. So, just one important point, not specifically related to today's session, but something important with respect to what was presented before the committee. So, they income tax department demands funds from revenue with respect to its operations and things across. I'll just read across what the reference point is. The committee notes difference between the projected fund requirement made by the Department of Revenue and the allocations approved by Ministry of Finance across its demands for grants. Matlab what demand was made and what allocations has been made. So it says particularly under demand number 36, which represents direct tax, against a projected demand of 20, sorry, It says out of a demand of 20 lakhs 69,000 crores, only 15, sorry, out of 20,000 crores, only 15,000 crores was allocated. So what was demanded was 20,000 crores. Allocation has happened only of 15,000 crores. So there was a net difference of around 5,000 crores, which it further reads with respect to indirect taxes. There was a projected demand, as in requirement, that was made of 49,000 crores by the department. Allocation of those funds that was presented was only of 27,000 crores. So there was a shortfall of 21,000 crores itself. So many a times I used to tell my friends during my internship days that जब डिपार्टमेंट के सिस्टम पे देखते हैं डिमांड दिखती है, हमारे सिस्टम पे देखते हैं रिफंड दिखता है. दिस एक्चुअली शोज क्वाइट लॉट ऑफ डिफरेंसेस फॉर द बजटेड demand that you're saying. Income tax department is saying we need funds and we'll allocate it. That fund allocation, there's a difference of 5,000 crores for income tax. For GST, there's a difference of 21,000 crores. Only in the demand and allocation. एक होता है मैंने मम्मी से 500 रुपये मांगे बोलने के लिए I'll buy books for 500. Out of that, if I spend 400, it is understood. But when I'm demanding 500 and I'm saying मैं 300 रुपये ही खर्च करूँगा, a question comes, what about of the rest? What of the rest 200? And this is only on projections. Reality they have still not presented, as in the figures weren't available. This is what has been presented. But just trying to say that this is something that we need to be a bit of aware of, which is very helpful. Further, it is a critique point that has been presented. In the view of department submission, that these reductions will not adversely affect. Basically, what was questioned to the department, अगर आपने इतने पैसे मांगे और कम allocation कर रहे हो, तो that would impact your functioning, right? If I have demanded X amount, I am allocating only Y amount, then the differential, it will have impact on the operations of department. It says, in the view of department submission, that these reductions represent to the 5,000 crores that has not been explained, will not adversely affect the modernization efforts, and the allocated funds are expected to suffice the anticipated expenditure likely to be incurred in fiscal year. The committee are inclined to observe that such significant variations between the projected requirement and the final allocation may indicate the need for further strengthening of internal budget estimation. So the budget on which the department works, many of our seniors over here, or most of you are senior to me, would know. Many a times we have seen practically that they say, हमारा target है, based on that target, an addition has to be made. So this is what practically we are not the only one who suffers. In fact, department tries to raise its targets at each and every case. So that is what I was just trying to present over here. So quickly coming back to our topic with respect to the preparedness and with respect to the Income Tax Act, the new Income Tax Act. My only thing is I explained to you that what has been mentioned, only limited number of forms would be available and the rest forms would be introduced throughout the year. The same is with respect to rules to an extent, but they are trying, in fact many of you might have read the news report also, that they are trying to expedite notification of rules and preparations of rules. My only thing over here is, now you might have heard, you might be well aware of that under the old act you had assessment year, you had previous year. Under the new law you have something called as tax year. That's the major differentiation. Under the old law you had Supreme Court decisions which did say the law that is existing as on the first day of the financial year would be the law that would be applicable throughout. Meaning, if a law is not implemented on 1st April, it will not be applicable to that particular financial year, it will not be particular to that assessment year. There are quite a few Supreme Court decisions for it. I'll just give you a reference of one or two. Kareem Tharavi Tea Estates Limited versus State of Kerala, which is 60 ITR 262, and Scandia Steam Navigation Company Limited, which is 42 ITR 589. What it specifically mentioned was, even under the Act, forget about the rules or the forms, if under the Act the law is not implemented on 1st April, the law automatically is to be applied into the next year and not for the current year. For rules, there is again similar precedent. So in fact, you had this case also wherein on 2nd April there was a notification issued. It was held that no, it cannot be applied for the relevant year, it has to be applied for the next year. With respect to rules, I'll just give you a reference, which is CIT versus Mirza Atuba Beg. Citation is 202 ITR 291. I'm saying, why is this relevant? This is relevant because we will certainly be into a situation wherein things are not implemented or probably notified on time. If that being the case, this might be helpful depending on what your facts are, depending on how the situation or your facts of the case are. Why? Because there is a clear stand that you can take that if the law was not notified, if sections are not notified, sections of course have been notified, but just giving a reference, if sections are not notified, if rules are not notified, even if forms are not notified and it is relevant for your case, and if it is beneficial, you can always take the stand that it is not applicable for that year, it will apply from the next year. This is something I just felt would be relevant for everyone, because this is I have this thing that this is what would surely happen. Along with the earlier case, there are quite a lot of cases. There are 4 to 5 cases that I have researched. I'll be sharing a presentation and it will be distributed to you all. In that, all these references would be given, so you can take reference of it. My another question, which none or rather what I understand or what I believe, in none of the sessions it has been spoken, discussed, or deliberated upon. See, everyone has talked about rules. Now what happens in rules? Rules are notified basically. So just for the sake of revision, we say rules are notified through notifications. Circulars are instructions given. Okay. Everyone has concentrated what is happening to rules. There has been government statement with respect to rules would be notified and this and that. There have been senior officials which have asked the ground field officials to work across on rules and notify it earlier. What happens to circulars? Because nobody has thought, or rather I believe it has not been much deliberated, what would happen of circulars of 1961? Whether 1961 circulars can be implemented or used for 2025 Act, or would we expect that within this few days, I guess 14 days, when the new year starts or the new financial year starts, you would have various circulars, hundreds. Last I had checked, there were more than 500 circulars. Those would be redrafted, reintroduced in particular sections. So very basic question that I had and which I just thought of researching, and I would like to present in front of everyone. Because if rules are not notified, we can take a stand that the day it would get notified, this will happen. But what about circulars? Try understanding there are many circulars which are beneficial for taxpayers. If I'll give a reference for capital gains, which is one of the things that I wanted to present, which I will be just touching across briefly. For capital gains, for characterizing whether it is a business income or it is capital gains, today we rely on circular. We rely on circular number 6 of 2016. That circular which is binding today, which is that is the only circular which gives quite a lot of help with respect to how the characterization of income with respect to capital gain should be. If this circular is not reintroduced, whether can you take benefit of this? Let's assume you have advance tax that has to be paid on June with respect to the income that you would be earning. Whether can you take benefit of this circular to characterize something as business income, to characterize something as long term? Because under the new act, what happens to circulars? There has been no specific discussion or even communication from departments and or from anywhere that new circulars would be issued, if they would be issued, when. Till the time they are not issued, what happens? If they are issued in July, what happens to the period from April to June? From which date would the circulars be effective? Or would it so happen that, through one circular, government will just write all the earlier circulars would be applicable to the new act? If the government does that, does it have the power to do that? If it has the power, under which section? How would the circulars be issued? There has been no discussion specifically. Now I'll not try to scare much on this, but I'll just give reference that there was earlier also a transition. There was a transition from 22 Act to 61 Act. With respect to that, I had the opportunity to research. So I had researched on it. There are quite a lot of decisions. Again, Bombay High Court is there. There's a decision of Krishi Utpanna Bazar Samiti versus ITO, 158 ITR 742. There's another decision of CIT versus Ajit Spices, which is a Kerala High Court decision, which is 165 ITR 755. Mind you, all these are old because this was dealing with the transition of 22 to 61. I was not even born when these decisions had come in, but I had to research it just to understand the gravity of situation. So a simple thumb rule for understanding is, yes, the old circulars will apply in totality to the new act, provided there is no change in the section, which is majorly the case in most of the cases. Only in some cases there has been amendment into the section. In some places they have tried to simplify the language. In that simplification, more harm has been done. But other than that, other than the sections wherein there are amendments, there it would be difficult to take the stand that 1961 circular would apply. Otherwise, it is safe to assume that the 1961 circular would apply to 2025 Act also. There are judicial backing for it. Again, the only exception being there should be no major material difference into it. For that, again, you would have to read the select committee report also. Because wonderfully, wherever there were logical arguments placed, it was said that it is out of beyond our scope. Beyond our scope meaning any structural or legislative changes that is being proposed. If there is a structural change, legislative change, the amendments have not been made or the suggestions were also not given, and it was clearly mentioned that it is beyond our scope. So wherever you feel that there is some amendment, do read the committee report on that section. Try to understand whether they feel that it is beyond their reach or not. And if they have recommended it, assuming there is some minor tweaking required or something, there is no major structural change, you can apply the 1961 circular over there. Now, I earlier spoke across on this aspect with respect to reduction of litigation and whether that has been achieved or not. So I'll just quickly give you a reference why I am so saying about it. See, friends, we all know Article 141. It says the law as interpreted by Supreme Court is law of the land, and Supreme Court decisions are given quite weightage. Today, on a topic of this is, I'll just give a passing reference, we'll not go depth into it, but I'm just giving a reference of house property versus business income. On this one limited topic, wherein a person is earning rental income, whether it has to be characterized as house property or whether it has to be characterized as business income. There are more than 10 Supreme Court decisions on this topic. More than 10 Supreme Court decisions. There was only one amendment that was made under section 28, a limited amendment. Beyond that also it is not helped. So I am just trying to say, on a topic where you require 10 Supreme Court decisions, until today it would be wrong, but I would just like to say, I can challenge anyone giving over here limited facts. As in, you correctly tell me whether it has to be characterized as business income or house property. There will not be a certainty. There is no answer to it. I'll give you example. If I own a property, I have given it on rent. I receive rent. There's a 11-month period जिसके लिए leave and license agreement हम लोग करते हैं. Take that case. Take a case of Airbnb. Same property. I am giving it on rent on Airbnb, meaning 2 दिन 3 दिन 5 दिन का रहता है. The characterization changes over here. Here itself, I am not saying ये head में होगा वो head में होगा. I am saying it's the same property. Purpose is also the same. Rent पे देके पैसा कमाना है, appreciation है. Just the difference in model, the model in which it is rent out. Things change across. I am saying on this limited topic wherein there are 10 Supreme Court decisions, there has been no amendment into the new act. If there is no amendment into the new act, then where is the question of simplification? जो इतना बड़ा टॉपिक है या पॉइंट ऑफ डिस्प्यूट है जिस पे 10 सुप्रीम कोर्ट के डिसीजंस आ चुके हैं, स्टिल देयर इज नो क्लैरिटी. आई एम नॉट सेइंग ये डिसीजन में ये बोला उसमें वो बोला, बट if it has taken 10 Supreme Court decisions, that means there would be some issue into it. After that, you have brought an amendment also into it, which again signifies that there is some issue. If this issue itself is not touched across, how will litigation reduce over here? The entire motive of the new act which was being said across, that litigation will be reduced. What is being tried is, they have tried to simplify the language to an extent. Through that simplified language, they say that litigation कम होगा. That is one aspect. But जो already litigation चल रहा है, if you are not bringing certainty to it, then what is the difference? Why was this entire exercise done? My simple question to anybody sitting over here is, what has been done under the new act? Few things have been deleted, few things have been redrafted. That could have been done into the old act also. So why was the new name given itself Income Tax Act 2025? इसमें और budget के इसमें फर्क क्या है? What is the difference that is being done? See, something like a direct tax code wherein everything is changed and the entire concept is being changed, I understand. What is done over here to bring it under as a new act? Because I am not saying that none of the issues are addressed, but I am saying if there is an issue wherein you require 10 Supreme Court decisions and still you are not touching that, then how are you reducing litigation? I will give another example which I just spoke across, capital gain versus business income. Earlier this was a very big issue because of 1038 exemptions and all that. Today also it creates quite a lot of issue because you have quite a lot of people participating into the equity market and securities market. So there has been 4 CBDT circulars issued only on this limited topic. There is a circular issued in 1989. There is a draft instruction which was issued in 2006. There is a circular in 2007. There is a circular in 2016. There are various High Court decisions. There is a Supreme Court decision on this also. I can cite the decision which is 35 ITR 594. My simple question is on a topic wherein CBDT itself has issued 4 circulars. If 4 circulars are issued by CBDT and still there is no clarity or there is no clarification given under the new act for this, then how are you reducing litigation? See, CBDT is not mad that it is issuing 4 circular. There is litigation being introduced. Even after the first circular, litigation continued. Even after the second, litigation continued. I am saying even the latest circular, which is quite back 10 years old, of 2016, it does not address the issue in totality. The question which I had mentioned of, or the fact that I had mentioned of Justice R.V. Ishwar, in his report, the very first issue that he had pointed out, he had given a reference, 80% of the income tax litigation is on this very limited topic. He had given a suggestion that under the Income Tax Act you introduce this, that up to 5 lakhs option would be given to the SSE, and he had given further suggestions to the government. That was not accepted. What did the government do? They bought a circular. Now try understanding. A legislative amendment under the act has different impact compared to what is happening under the circular. circular is not that forceful. What did the government do? It brought out a circular on this. I am saying on this topic today also there is quite a lot of litigation. You have Supreme Court decision trying to say that circular is not binding on the SSE. I can still say what circular says is not applicable to me, and I can take my new stands. What I am basically trying to put forward is on a topic where the government itself required to bring in 4 circulars, and that topic has not been touched, then how are you reducing litigation? These are the live topics on which litigation happens. If these topics are not touched, how do you even claim that litigation is being reduced or that is the objective? Why I am putting these concrete facts is, I could have just started with the session. It is a good thing that has been done. I could have downloaded the press release. These many words have been deleted. This has been simplified. But that is all cosmetic. How is it going to impact anyone over here? Everyone is literate enough to understand what is relevant under the act, what is not. जो सेक्शन नहीं पढ़ना होता हम वो छोड़ देते हैं. Deletion, addition, to an extent everything is extended. But then what was the need to say that this is a new act? 1961 could have been continued. If you have to delete, you could have done it through your budgetary sessions that you always do. My entire emphasis and few other points that I'll mention across is most of the things that is being talked across is cosmetic in nature. I'm not saying कि कुछ भी नहीं हुआ है or something. I'm saying look at the mammoth efforts that have gone into this. Department prepared it, it went for drafting, redrafting, it was removed, reintroduced, you had select committee, all over India tour किया था. Not me but various organizations, they wasted their resourceful time into giving delegations before the committee. When representations were done before committee, in half of the cases they say this is out of our purview, and in the recommendations that have been given also by the committee only half has been accepted. I was like, then what has been the entire reason for doing this? I'll move ahead into it. Just few references. There's this section 222E which is called deemed dividend. In that, very basically everyone would be knowing that if we take loan in the form, it would be considered as deemed dividend in a private entity. This was done because people didn't want to pay dividend distribution tax that was earlier, so this concept was there. I'm saying in this also you have contrary decisions. The entire controversy is tax लगेगा किस पे deemed dividend का, shareholder पे लगेगा कि firm पे लगेगा. You have 2 contrary Supreme Court decisions. One is Madhur Housing and Development Company, which is 401 ITR 152. You have National Travel Services, which is 401 ITR 154. Within a span of 1 month, you had 2 Supreme Court decisions giving 2 contrary views, making a reference that a larger bench has to be formed and this controversy has to be resolved. Now my simple thing is, if you have to reduce litigation, why wasn't this thing touched? Today also if I try to ask any one of you, किसको tax लगेगा? Some might give answer this, some might give answer that. Now when amongst us only, if we don't have certainty over it, then what is the entire purpose of this new law which is unable to provide certainty? See, litigation happens when there is uncertainty, interpretations में issue आते हैं. So government had thought कि हम active passive कर लेंगे, it will reduce most of the issues. To a very limited extent, yes, it is helpful, but it cannot be unless major implementations have been done into this. So what I am just trying to bring forward is major issues that are existing today have not been touched across under this Income Tax Act itself. So there should be no much great fear कि act में क्या change है क्या नहीं. There are certain amendments which are good. There are certain things which are commendable, wherein cosmetic changes that I call it. एक schedule में सब डाल दिया है. It has been incorporated together. Like Nihar bhai was talking of charities. So today if you see charities section 11 कहीं पे है, 13 है, and 115 TD उसका accreditation tax कहीं और है. What has now been done? Everything has been summed up under the one section, which is fine to an extent, but that is not causing some material impact or change, which should have been the need of the hour. Just a very basic concept of business versus profession. Now, why this is relevant? Okay, let me just mention across. Under the Income Tax Act, you have business, the word business that has been defined. You have the word profession that is also defined. It says profession includes vocation. Now, over here, a question is whether business includes profession or not. Why this is relevant, I'll just give a reference. If you see presumptive taxation or anything, under presumptive taxation, what you will understand is 44 AD deals with business, 44 ADA deals with selected profession. A basic question is selected profession के अलावा बाकी कुछ profession होगा, whether it falls under 44 AD or it falls under 44 ADA. That's a genuine doubt which most of us should face. There's a Supreme Court decision of Barendra Prasad Ray versus ITO, which is 129 ITR 295. In that, it was pertaining to section 9. तो उसमें ऐसे था कि the lawyer was saying that only business income is to be taxed and business does not include profession. So Supreme Court said no, business includes profession, wherein the concept was under section 9 it had to be taxed. There's another decision which is GK Choksi and Company. It's a very famous decision. 295 ITR 376. In this it was said that it was pertaining to depreciation. Business does not include profession. In one case Supreme Court had said it includes, in one case it says business does not include profession. So today what is the clarity over it? It's not known. Why is it important? If business includes profession, so any other professional who is not a specified professional under 44 ADA, you can go under 44 ADA and get it taxed at 8%, 6%. This controversy is there. You again have contrary Supreme Court decisions that have not been touched across into. Now, just one thing that I'll quickly mention across, which should stay with you and you should understand. There's this ITAT provisions, or rather the provisions pertaining to ITAT, which is 254 of the old Act and 363 of the new Act. It talks of stay of demand. The section itself says, even if it is a fault of the SSE or not of the SSE, 365 days के beyond ITAT cannot grant you stay of demand. मतलब अगर प्रोसीडिंग्स तुमने डिले की या डीआर ने डिले की, वॉट एवर बी द केस, ITAT कैनॉट ग्रांट यू दिस. सुप्रीम कोर्ट हैज स्ट्रक डाउन दिस प्रोविजन. इट इज़ इन द केस ऑफ DCIT versus Pepsi Foods, 126 taxman.com 69, way back in 2021. Look at the audacity. Supreme Court has struck down this provision. The provision has stayed into the 1961 Act. आज भी आप खोलोगे सेक्शन 254 सबक्लॉज 2A, उसका थर्ड प्रोवाइजो पढ़ोगे, ये सेम वर्डिंग्स हैं, whereas Supreme Court has struck this down. The same thing has been blindly copy pasted under the 25 Act itself. मैं तो बोलता हूँ 1961 में ही नहीं होना चाहिए. Supreme Court has struck this down. It has continued in 1961. It has travelled back in 2025 also. So even a case wherein Supreme Court has said that something is not applicable or this has to be struck down, it is not even read down, it is struck down. That has still stayed in the 1961 Act. It's like, if I would calmly say, kind of disrespecting the Supreme Court decision. But I'm just trying to say that it has stayed in 1961 even after 4 to 5 years. And today it has travelled to the 2025 Act as well. So this is something that I just thought is something that we should remember, or we should understand what are we dealing in and why are we dealing this into. See, I could have just gone ahead and explained क्या structure है, क्या नहीं है. That you can just Google and you will find the first 25 links with the same reference. क्या हुआ है, क्या नहीं. In fact, the best thing is see the government press release. I just thought that I'll take this opportunity to actually tell you that on ground reality there are quite things that has been missed. So I in this session just thought let me try to make it like an eye opener. Rest of the actual amendments or few things that have been, pertaining to that particular section reference would be taken, of course, by Ashok Bhai and the other speakers as well. I tried my best of, presenting not a bird's eye view, but a view that could pierce through what has been presented. So, thanks for the patient hearing.
Thank you, Chirag.
Thank you, Chirag. Now I would request our past convener, CA Vijay JM, to offer a vote of thanks to today's speaker.
All are requested to be seated for just 5 minutes.
A warm good evening, members. It's my pleasant task to propose a well-deserved vote of thanks to our speaker Chirag Bhai, who has dealt with the today's topic of bird's eye view on new Income Tax Act in a simple and lucid manner. He has explained how this bill was formed, how the selection committee or the standing committee has made such a changes that has horribly brought this bill into existence, how they have solved this problem, and from 1st of April 2026, we have to deal with this act. Chirag, we are indeed thankful to you for accepting our invitation, and you have spent a lot of time in preparing a topic so that we can get benefit of your experience. On behalf of WIRC, on behalf of Borivali Center CP Study Circle, I propose a well-deserved vote of thanks and request a member to carry out the loud applause. Thank you.
We welcome our second speaker of the session, CA Ashok Mehta. He is going to take a topic on decoding of income tax under various heads of income. So it is going to be interesting. So we would have a break for 15 minutes and we will catch back again. Thank you.